Hi, everyone, and welcome to the second in our series of 10-minute talks focusing on the upcoming changes that the government are introducing by way of the Employment Rights Bill. In each of our sessions, we're going to talk about a different section, different parts of the bill and what the implications are, particularly for employers. And I'm Beth Hale, I'm a partner at CM Murray, and I'm delighted to be joined today by Mitchell Blythe, who's our trainee. And Mitchell's going to sort of kick off with asking some questions about the key changes in the bill.
Hi Beth. So the first thing I want to discuss is that in October last year, a new preventative duty was introduced on employers to take reasonable steps to prevent sexual harassment in the workplace of employees. The Employment Rights Bill seeks to amend the wording slightly on this, from the duty to take reasonable steps to prevent sexual harassment to the duty to take all reasonable steps to prevent sexual harassment. Can you talk to us just a little bit about how significant this one word addition could be? And what this would look like in practice, the duty to take all reasonable steps as opposed to a duty to take reasonable steps.
Yeah, thanks, Mitchell. I mean, I think that just a little bit of sort of history of the passage of that previous bill through Parliament was that the original wording of the preventative duty was an obligation to take all reasonable steps, and the word "all" was removed as it went through Parliament. And one of the Labour Party's kind of commitments was that they would reintroduce that "all" when they came to power, and that is in fact what they are now seeking to do. I was trying when I was preparing for this to work out a sort of way I could make some reference to a one small step for giant leap kind of reference, but I've totally failed. But consider that sort of what I'm saying. It's a tiny word, but it's actually quite a big difference to the meaning, because taking reasonable steps is really there's a discussion about what is reasonable. You might think about what's the sort of size, resources of an employer, what's reasonable in all the circumstances. Taking all reasonable steps is actually significantly more onerous. That bar is higher and will be higher for employers in terms of what they have to do. And the government have said they're going to publish guidance on what all reasonable steps are. And I think employers would be well advised to take all the steps that are set out in the guidance. And there will be, I would have thought, some sort of, that will vary from industry to industry, from employer to employer. But I think employers will have to be, most employers will have already thought quite hard about how they sort of put in place the mandatory duty to prevent, in advance of it coming in October. But I think they will have to keep on thinking about that, and that has always been a kind of movable feast, if you like. There's always been it's not just you put in place your policy in October 2024 and then you don't think about it again. It has to always be responsive and reactive, and if there are incidents, if something does happen or something occurs which sort of changes the approach that the employer might take, or alerts them to some issue which they hadn't previously been aware of, then they have to sort of change their policy, put in place extra measures, and that need will become even more acute when this change comes in. The difference, sort of what is the difference between reasonable steps and all reasonable steps, is a little bit how long is a piece of string, like what does it mean? But I think what it really means is that the bar is higher for employers. They're going to be expected to put in place really robust measures to prevent sexual harassment, and a big part of that will be, what do they do when something happens? It's not just about, it is obviously a duty to prevent, but how do they respond to incidents as they occur? And how do they then change their policies to sort of minimize future risk once things have happened? So it's a anticipatory obligation, but it's also a responsive obligation.
And taking into account, obviously, that we're still waiting for the guidance to be published, and obviously, as you say, how long's a piece of string in terms of what the differences could be. Could you think of any sort of examples of things that employers should consider doing in order to comply with the amended wording?
Yeah, so I mean, obviously, I think we'll come on in a bit to timing, but I think it's likely that this won't come into effect until sometime in 2026, possibly quite late on in 2026. So what can employers be doing now is a little bit difficult to answer, but I think just making sure that they, as I say, that they comply with their existing policies, that they review and amend on an ongoing basis their existing policies and risk assessments on sexual harassment in the workplace and think about what that looks like. And then if they just think about what steps they are taking to prevent sexual harassment in the workplace and what else they thought about as part of their risk assessment. And if there are steps that they thought about as part of their original risk assessment but decided not to take, to revisit that and think about if that bar is raised, if I'm required not just to take reasonable steps but to take all reasonable steps, should I be doing those things that I thought about but discarded back in sort of September 2024 when I was thinking about this originally?
That's great. And what can we expect the remedy to be for any sort of failure by the employer to abide by this new amendment?
Yeah, so that, I mean, that hasn't changed. That doesn't seem to be. Doesn't seem to be any proposal to change that. So the remedies are either as part of a pre-existing claim for sexual harassment. It relies on for an individual enforcement. It relies on a successful claim for sexual harassment by the employee, and then if they can then show that the employer did not take all reasonable steps, that they can be an uplift to their compensation. But also there is the possibility of enforcement by the regulator, by the Equality and Human Rights Commission, who can take action against employers they consider are not taking reasonable steps, taking all reasonable steps. And there was a recent example of that kind of action being taken by the EHRC in respect of McDonald's. And I think we can expect the EHRC, subject to their resources, which are limited as always. I think we can expect to see a bit more enforcement action in that regard, and particularly as that sort of bar is raised in respect of what steps employers have to take.
The next part of the Employment Rights Bill we wanted to discuss today was the Employment Rights Bill will also be reintroducing the employer liability for third-party harassment of employees, which was previously removed from the legislation. Employers will be at risk of being liable for third-party harassment unless they can demonstrate that they took all reasonable steps to prevent the harassment, like we just discussed. What are the key differences between this proposed change and the current position?
Well, currently there is, I mean, there's a little bit of legal, sort of technical legal argument about this, but broadly there is no standalone claim for an individual against their employer who is harassed by a third party in the workplace. So third party means clients, customers, consultants, other people who are on the premises or in the workplace who aren't employees or agents of the employer. Without going into the legal technicalities, let's say broadly there is currently no standalone claim for people for individuals harassed in the workplace by those sort of third parties. There did used to be a claim for third party harassment in the Equality Act. It was slightly complex and convoluted. There was a sort of three strikes and you're out kind of mechanism, and it was repealed in 2013 by the government at the time. So since then there's been sort of no standalone claim. This is a really significant change, and it applies not just to sexual harassment but to all types of harassment in the workplace. And imposes an additional duty, and it's very, very closely linked with the provision we were just talking about, because it imposes a duty on employers essentially to take all reasonable steps to prevent third-party harassment. Now, there's been quite a lot of press coverage of this one. I read an article a few weeks ago saying that pubs are going to have to start banning certain topics of conversation in their their premises to avoid their staff feeling harassed by conversations that other people are having. I think that. I think that's probably an overreaction. It has always felt like a kind of a gap in the law, that people aren't protected in that way. And obviously we can talk about law firms and staff being harassed by clients, but we can probably more commonly think about people working in the hospitality industry, in bars, in restaurants, and also in nightclubs and theatres, those kinds of places where they are where workers are routinely, day in, day out, exposed to the conduct of third parties, and also in healthcare, and so people working with patients in healthcare settings as well. So it is it's a big change, and it imposes a significant sort of extra thing for employers to think about. But I think again the focus will be on reasonable steps, and also on the definition of harassment. Just, ordinarily overhearing someone talking, expressing a view that you don't agree with is unlikely to be sufficient grounds to on which to base a claim of harassment. It probably ordinarily that wouldn't pass the sort of get over the hurdle of creating an intimidating environment or violating your dignity that is required to bring a successful harassment claim. So I think there is a sort of knee-jerk reaction to go, oh, we're going to have to ban everything and everyone from talking about anything at all sensitive in any workplace ever. And I think there is, if you row back from that a bit and just think, actually, how can we protect our employees? What can we do? Can we, for example, put up signs in the workplace saying harassment of our staff is unacceptable and we will take action? If people are harassing your staff in the workplace, you eject them from the premises. For example, in a pub, you might sort of kick out people who are from the premises who are harassing your staff. So I think it's not about being sort of thought police and stopping people from talking about difficult subjects, because obviously that is, I think that is sort of slightly unreal. But it is just about putting in place protections for your staff to make sure that your customers, your clients, are clear about what the expectations are. And again, I think it is all, you have as an employer, you have a defence if you've taken all reasonable steps. So that is quite a high bar, but I suspect that test will be slightly different to the test for all reasonable steps to prevent sexual harassment that we were talking about earlier, and that actually what is reasonable for those purposes is likely to be slightly different from what is reasonable in respect of the duty to prevent sexual harassment.
So two big changes coming. Do we have an anticipated timeline for these changes at all yet, Beth?
Well, I think, as I said earlier, I think probably 2026. We don't know exactly. The government have said they're going to consult. They're going to put in place work with ACAS and EHRC to produce guidance. So there is some significant work to be done. The government, the sort of appropriate departments of government are talking to interested parties, and I think it's going to take a bit of time before the details are actually finalised. But I would have thought 2026 at some point.
And in light of that anticipated timeline, would you say it's too soon for employers to start acting now to get in place for these changes?
Well, I think probably too soon to put in place formal, to really sort of amend policies in light of these changes, but preparing for them, I would really recommend. As I said earlier, thinking about what your policy says now, what might have to change, what you should be thinking about changing in respect of that sort of increase in obligation. How can you prevent not just sexual harassment, but what steps can you take to prevent other types of harassment too? What wording can you put in client and customer communications, those kinds of things. I think that's really, employers could be putting in place measures to protect their staff sooner rather than later, even if that they then have to change again further down the line. These are fluid things, and they are going to keep changing, but employers would do well to really just keep thinking about their policies and procedures in this area and what they can do to improve them, and kind of watch this space and see what guidance looks like when it is published. Thanks so much, Mitchell, for putting the questions and discussing these issues today. Thanks everyone for listening and watching, and we will be releasing a third in the series on the Employment Rights Bill in due course. Thanks a lot.
Thank you.